Thank you. Good afternoon. Thank you all for taking time and coming to this seminar. I was asked to focus on some urban health issues relevant to Louisville, and since it's a Gaines Foundation seminar, also to focus on ethics and policy. I'm going to be talking generally about mental health law and policy issues. With respect to a health policy background and context, and especially mental health law, I want to first recognize that there's a mental health policy issue recently from NIMH. They've decided to start substituting lawyers for rats at NIMH. And there are three policy reasons for doing that. First of all, there are more lawyers than there are rats. Secondly, you don't get as attached to lawyers as you do to rats. And thirdly, and perhaps most importantly, there are some things that rats won't do. So NIMH is changing to lawyers. Regarding mental health law and policy, and as a health policy background and context, in the Petula lecture at the 2008 annual meeting of the Association of University Programs and Health Administration, Karen Davis, who's president of the Commonwealth Fund and former chair of the Department of Health Policy and Management at Johns Hopkins University School of Public Health, provided a state scorecard summary of health system performance across 32 dimensions of access, quality, avoidable hospital use and costs, equity, and healthy lives. In my courses on health law and policy and mental health law and policy, those get distilled down to quality, cost, and access, the usual tripod. In the law, we focus very much on a fourth leg, which is autonomy or personhood. So re-dividing it into access, quality, avoidable hospital use and costs, equity, and healthy lives, and 32 indicators of those, the state of Kentucky ranks 45th on this state scorecard. This is the bottom quartile of the 50 states. Specifically regarding Kentucky's health challenges and the state's health status, in September 2007, Professor Michael Samuels, who's the endowed chair in rural public health policy at the University of Kentucky, reported that while Kentucky ranks 28th among the states in the proportion of its population age 65 and older, Kentuckians who are 65 and older have exceptionally high rates of personally ascribed disability, 48.6%, compared with a national average of 40.5%. Kentucky ranks fourth in the nation in disability rates among persons age 65 and older, which indicates that given the status quo or worsening health status, the state will likely incur higher costs for the care of elders in the coming years as the baby boom population reaches retirement age. So current phenomenon are going to be exacerbated by the aging of the baby boom, which includes the aging of the disabled population. This seminar will focus on legal and ethical issues in mental health or mental disability law and policy, including my research on one of the legal mechanisms for addressing disability, and that is guardianship. More specifically, as a public health background and context for mental health law and policy, NIMH states that 26% of Americans 18 and older, 1 in 4 adults, suffer from a diagnosable mental disorder in a given year. The main burden of illness is concentrated in the 6% of the population, 1 in 17, who suffer a serious mental illness. Mental disorders are the leading cause of disability in the U.S. and Canada for ages 15 to 44. 45% with any mental disorder meet the criteria for 2 or more disorders, with severity strongly related to comorbidity. Mental illness, including suicide, accounts for over 15% of the burden of disease in established market economies such as the United States. This is more than the disease burden caused by all cancers. More specifically regarding the health policy context and focusing on urban health issues and mental health policy, schizophrenia and anxiety and personality disorders are more prevalent among urban residents than rural residents. Research in Detroit found psychological distress highest among African Americans and whites living in high poverty areas. A Baltimore study found an association between high-stress disadvantaged neighborhoods and depression. Additional Detroit research showed that psychological distress and adult drug use are associated with neighborhood disadvantage. Regarding available Kentucky data, Professor Samuels reports 1,046 drug arrests per 100,000 population in Kentucky, compared with 700 drug arrests per 100,000 in the United States. And the highest Kentucky county has 2,764 arrests per 100,000. At the same time, there is little or no support for the proposition that there's a significant relationship between mental disorder and race. Race alone does not appear to produce higher rates of mental disorders for particular groups. Mental disorders among members of racial minorities seem to be largely due to also being poor. I was talking with Dr. Tasman earlier this morning, and we discussed regarding further implications for Louisville and urban health policy issues in the state of Kentucky, the problem of mental illness stigma, which does exist as far as the African American population is concerned. Now, what I'm going to talk about regarding mental health policy and law is essentially introductory educational material, a conceptualization of the mental health system from a law and policy perspective. This is introductory material for an elective course on mental health law, for a potential curriculum on mental health law. It also is a map or diagram of a general research agenda as well as my personal research agenda. I hope especially to introduce you to mental health policy and law and the mental health system. Let me start out with what I mean when I talk about mental health system, particularly from a legal standpoint as well as from an ethical perspective. For purposes of this discussion, I'm defining mental health, the mental health system, as the various agencies delivering mental health care, the various entities or agencies delivering mental health care, and those portions of the judicial system with jurisdiction over proceedings to compel persons to submit to such care. It's unusual in health care that there is this separate system for any particular health condition. Nonetheless, there is, as far as the law is concerned, this separate mental health system, which I'm emphasizing includes proceedings to compel people to submit to care. Another definitional feature for mental health is when I talk about mental health, I'm not only talking about people who are mentally ill, who have mental illness, but also people who this system, this structure, this legal description, and the statutes that apply to the mental health system resonate and are similar to statutes not only for people with mental illness, but also for people with developmental disabilities, people with alcohol problems, people with drug problems. So when I talk about mental health here, and particularly legal and ethical issues, the legal and ethical issues usually apply not only with respect to people with mental illness, but also people with developmental disabilities, substance abuse problems, including both drug and alcohol problems. Another interesting population is children and children's mental health law. The issue of children is very interesting, but even more complicated legally. Now, if our mental health system is then including the proceedings to compel people to submit to care, the mental health system legally and as a policy matter really is a hybrid system. It's a combination of the criminal justice system and the healthcare system. We're probably fairly familiar with the criminal justice system. It's an important legal value as far as the criminal justice system is concerned that there is this presumption of innocence. And as a system in the criminal justice area, the presumption of innocence means that the legal system says we're going to presume that you're innocent, and as a legal matter, we're going to hold you responsible only if you are found guilty beyond a reasonable doubt, jury of peers, due process. We've got a presumption of innocence. This means from a system standpoint that we err on the side of letting criminals, letting people who performed bad behavior, who committed crimes. Our system errs on the side of letting people be free who nonetheless probably committed crimes. So the errors we commit, we err on the side of physical freedom, we err on the side of physical liberty. On the other hand, from an error standpoint, while not unusual, the likelihood that somebody who has been found responsible in the criminal justice system really did do it is very high. There are, of course, situations where people are on death row and the legal system was unjust as far as some of those individuals are concerned. They've been found through various technologies like DNA testing and so forth not to have committed the crime. But by and large, most of the errors are on the side of physical freedom, liberty. In contrast, you can think of other countries and other legal systems where instead of a presumption of innocence, there's a presumption of guilt. And you have to prove your innocence, which is challenging as a social legal system, of course. So in the criminal justice system, we have our presumption of innocence. You all have some familiarity with the presumption of innocence. Shift over to think about the health system as a matter of law. In the health system, we start out with a presumption of competence or capacity. So for adults, we start out with a presumption of competence or capacity. This again means, as far as the American legal system is concerned, that we will err on the side of having people who are not competent, who are incapacitated, make bad decisions, silly decisions, stupid decisions, decisions with bad results. Our legal system errs on the side of presuming competence, and if somebody is legally incapacitated, you have to allege that they're incapacitated and prove that they're legally incapacitated by clear and convincing evidence through the opportunity for a civil trial. So we have this presumption of competence. And this means, as far as the health system is concerned, we can boil it down to a certain extent legally, if not ethically, to you can consent to or refuse any and all treatment, even if the consequences are that you die. And as a matter of law, if not ethics, the legal system protects that ability. We again have the errors I described. We err on the side of the consequences of this presumption of capacity. What I've been studying, of course, is the guardianship system, which is the system that handles people who are found to be legally incapacitated. And it's a challenging system, and particularly for people who are without willing and responsible family members or friends to serve as guardians, or without the resources to hire a professional guardian. What I'm describing in theory is problematic in practice because of the dearth of the supply of good professional guardians or a public guardianship system. My guardianship research agenda since the late 70s has essentially been spent assessing the extent to which guardianship and public guardianship assists or hinders the elderly and disabled persons and securing access to rights, benefits, and entitlements, including health. So I've been focusing on the incapacity guardianship side of the health care system with implications for health care, including mental health. So we have some sense for the criminal justice system on the one hand and the presumption of innocence, the healthcare system and the presumption of competence, the ability to consent to or refuse any and all treatment even if the consequences are that you die. Those two systems are fairly clear legally and ethically. The mental health system is complicated, more complicated. It's not just a health system, otherwise I could stop right now. It's also not just a criminal justice system. Again, otherwise I could stop with the description of the criminal justice system. It really is a combination of both. And remember that I'm talking about defining the mental health system as the proceedings to compel people to submit to care. There are two basic authorities for compelling people to submit to mental health care: the parens patriae authority and the police power authority. The police power authority, grounded in the 10th Amendment, gives states and by delegation local governments authority to secure generally the comfort, safety, morals, health, general welfare by preserving order, preventing conflicts of rights, and increasing enjoyment of privileges. So I would emphasize on the police power. The police power, while it sounds like it's the police, cops, the criminal justice system, the police power really is the authority of the state over safety, morals, health, general welfare, and especially public health. And here, as far as public health is concerned, and to help understand the police power aspect of the mental health system, I would emphasize in public health, for example, the authority of compulsory vaccination and quarantine. Compulsory vaccination and quarantine are constitutionally relatively non-controversial. And the police power in mental health accounts for one part of the civil commitment authority. The other part is the parens patriae authority. Now, in most states, the involuntary civil commitment criteria for people with mental illness, developmental disability, drug abuse, alcohol abuse, children are separate. The authority, there is both police power and parens patriae authority and responsibility. And the criteria in most states for those four situations generally says you can involuntarily civilly commit someone if they have the predicate condition, mental illness, and by reason of the mental illness, a causation element, they are dangerous to self or others, or they are in need of care and treatment and unable to take care of themselves. Now, since this is a state responsibility and authority, not a federal government authority, there are 50 different versions of that, of what I've just said. So if that formula is not exactly what it is in Kentucky or the state you're familiar with, it's because Kentucky's is, when you look very closely, probably not identical to any of the other 49 states, and that's true for every other state in the country. But the criteria, again, generally are mental illness, the predicate condition, a causal relationship, so mental illness, and by reason of mental illness, dangerousness to self or others, or unable to take care of oneself, and there's arguably a constitutionally implicit criterion of being incapacitated. The police power side of that, the public health, morality, public safety especially, is mental illness and by reason of mental illness dangerous to others. And the police power authority, mentally ill and dangerous to others, really achieves preventive detention, legal preventive detention. In the United States, preventive detention in the criminal justice system is rarely, if ever, utilized. It's unusual. In the criminal justice system, somebody has to actually have perpetrated a crime. It can't be a situation where you're predicting that they're going to commit a crime, but rather they have actually committed a crime and there's evidence for it. With the police power, mentally ill and dangerous to others by reason of the mental illness, historically you've been able to go just on the basis of the prediction. And we know from the available research that our ability to accurately predict dangerousness is limited. A famous law review article had a secondary title of Flipping Coins in the Courtroom. Most of the available research says you can predict dangerousness less accurately than flipping a coin. There's an update of some of that research that indicates if you're talking about really short-term prediction of dangerousness, the accuracy goes up. Nonetheless, the error rate compared to the criminal justice system is quite high. So we will predict some people to be dangerous who are not in fact dangerous, and we will predict some people to not be dangerous who in fact are dangerous, false negatives and false positives. So we have some problems with police power commitments, at least in terms of the efficiency and accuracy of the system. The parens patriae authority is the authority of the state to take care of those who can't take care of themselves. It's the role of the state as sovereign. Notwithstanding too many years of Latin, I learned most of my Latin through law, most of my English through Latin, but never quite learned Latin. Parens patriae is the parental authority of the state to take care of people who can't take care of themselves. Blackstone used what is now politically incorrect language. Please understand and appreciate that I'm quoting Blackstone. Blackstone characterized the parens patriae authority as the authority or responsibility of the state over, quote, infants, idiots, and lunatics. Infants being children at the time, idiots being persons with developmental disability, lunatics at the time being persons with mental illness. So it's the responsibility of the state to take care of people who can't take care of themselves. Or in working with the Florida legislature, I was struck on one occasion when there were serious budget cutbacks, and we were talking about funding for mental health programs, and the various community mental health centers and other stakeholders were coming to the legislature for funding. And the mental health program director of the state said, you know, this is all well and good, and there are lots of important stakeholders and providers and so forth, but if we don't take care of indigents with mental illness, nobody else will take care of them, and as far as the state is concerned, this is the top priority. So we hear all the other stakeholders, but as mental health program director, I've got to see to it, the mental health program director said, I've got to see to it that there is funding for people for whom no one else will provide service or take care of them. Under the parens patriae authority of taking care of people who can't take care of themselves, that part of the civil commitment criteria is mentally ill and because of mental illness, unable to take care of themselves. There are constitutional arguments that for a viable civil commitment statute, what that means, some states say explicitly, other states implicitly, is mentally ill and because of mental illness, unable to take care of themselves because they are legally incapacitated. So the parens patriae authority is strongest when the parens patriae side of it explicitly, if not implicitly, includes a criteria of legal incapacity. Nonetheless, in many states, when someone is found to be mentally ill and in need of care treatment and they can't take care of themselves, it's rare that a guardian, a substitute decision maker, is appointed for them to make decisions. In fact, historically, public hospital superintendents literally acted and had the formal authority to make medical decisions for such individuals until historically that was found to be a serious conflict of interest. However, in many states, a public guardianship system to fill that void is yet to be viable. Now, the problem with the parens patriae authority in its implementation, as well as conceptually, is that, first of all, you don't have a substitute decision maker appointed to make the guardian, appointed to make the medical decisions for the individual. Secondly, many states don't explicitly require a finding of legal incapacity. And you have a significant population in real need, but from a public health triage perspective, they receive lower priority than the police power population. So we have a series of problems with the civil mental health system. Now, in the last generation or so, since the early 70s, the United States Supreme Court has issued a series of decisions, and there have been other significant landmark decisions that have clarified the various means of getting through these various systems and to mental health services. So all of these are the various approaches to obtaining mental health services. In the criminal justice system, there are roughly 5 ways of getting out of the criminal justice system and to be getting mental health services. First of all, before one is actually arrested, there's the opportunity for diversion. So, for example, a police officer has the discretion to either arrest the individual or to say, you know, on the one hand, we can arrest you for some low-level misdemeanor, whatever the situation that the officer is facing may be, or we can divert you before arrest to an appropriate mental health service. Mental health, again, defined broadly to include mental health, drug abuse, alcohol abuse, services for the developmentally disabled. So we can have diversion before arrest. And we can have systems, and many states and communities, cities, have programs more or less formally organized to divert individuals from the criminal justice system and into appropriate mental health services before arrest. After arrest and before trial, there's an opportunity for mental health services through incompetence to stand trial. So before someone is processed through the criminal justice system, the United States Supreme Court has said you can't stand trial if you're not competent to understand the charges against you and assist in your own defense. Incompetence to stand trial. So someone found, first of all, assessed to determine whether or not they're competent to stand trial. And then if they're found by the court to be legally incompetent to stand trial, gets sent for mental health services to restore their competence to stand trial. Now, here there starts a series of very interesting phenomena, historically and in some jurisdictions. The amount of time spent, the available social science research shows that the amount of time someone spends incompetent to stand trial is not associated with their diagnosis or their treatment. The amount of time they spend incompetent to stand trial, being treated for their competence to stand trial, is associated with their predicate crime. So someone charged with burglary versus someone charged with homicide is going to spend less time generally in the aggregate being incompetent to stand trial. Thus, incompetence to stand trial becomes a social control mechanism, very much a criminal justice adjunct for socially controlling somebody who's alleged to have committed a crime. They haven't been convicted. They've been diverted, supposedly because they're incompetent to stand trial, The treatment now has evolved to the point that what it consists of is we're going to educate you about what the charges are against you and what a trial is. Ironically, it's a legal education conducted by mental health professionals, are the best programs. And then you're going to be returned to trial. And as I've indicated, it's the important variable is the predicate crime and not so much the diagnosis or treatment. So if someone's found incompetent to stand trial, they can be, when their competence is restored, they get sent back. There's also been the problem or challenge of what if someone is incompetent to stand trial and they're not restorable? Their competence is not restorable. What do you do with them? And we've had a series of legal decisions addressing what can be done constitutionally, how long they can be held incompetent to stand trial, what, if anything, should be done with them if they can't, in fact, be tried, the extent to which they could be tried while on psychotropic medications, the extent to which there should be some kind of alternative trial process, and a variety of other policy issues for handling this population. This so-called forensic population of these systems between the criminal justice and the mental health system, the largest numbers really are this incompetent to stand trial population. The one that receives the most scholarly attention, hundreds and hundreds of law review articles and psychiatry articles, is the not guilty by reason of insanity population. So somebody arrested and tried can raise the affirmative defense, the insanity defense. The formula for the insanity defense, there are about 4 of them. They vary from state to state, but it's essentially that you're found not responsible, not criminally, not legally responsible for your behavior. You're acquitted by reason of insanity. Insanity being a legal term, not a clinical term. And as I've indicated, it's defined differently in the states. So you're acquitted by reason of insanity. Now, the theory about acquittal by reason of insanity is if you're acquitted, you're not responsible. And if you're not then civilly committable, you should walk. You should be released. We again observe some social control phenomenon here because when someone is acquitted by reason of insanity, it's actually unusual that they walk. They usually get committed. They should be committed through the civil commitment system, but there are some states that formally or informally automatically commit, I'm describing the behavior, not the law, automatically commit persons acquitted by reason of insanity. So they're acquitted by reason of insanity, and what happens to that population? In the first place, where do you put them? In the second place, what do you do with them or to them? Assuming they get some kind of treatment, and you look at that population, you can again find that the amount of time someone spends incarcerated, whether it's a criminal facility or a mental health facility, the amount of time they spend physically incapacitated, acquitted by reason of insanity, is associated again not with their diagnosis or treatment, but with their predicate crime. So if they are acquitted by reason of insanity of homicide or shooting President Reagan, they're going to spend a longer time in St. Elizabeth's Hospital in the case of President Reagan's assailant. They're going to spend a longer time acquitted by reason of insanity for homicide than they're going to spend if they're acquitted from burglary or a misdemeanor or something like that. So we again have a social control phenomenon occurring with respect to the not guilty by reason of insanity population. Another way of getting mental health services is a sentencing alternative. You have the alternative of jail or prison or mental health service. Another way of getting mental health services is in correctional programs. And this can be in 2 ways. One, by analogy to the healthcare system, just as someone could have or develop cancer or diabetes and they're in prison, so one either has or can develop a mental health problem defined broadly in prison. They could be treated on a voluntary basis, legally and ethically, as with cancer or diabetes if they were in prison, or for the mentally ill, people with mental illness, they can be transferred to a mental health facility. And the Supreme Court has a series of decisions addressing the criteria and procedures for transferring people from a correctional program to a mental health program. Generally, you're talking about incapacitated to serve a sentence, incompetent to serve a sentence. This gets its most interesting, reaches its most interesting limit with incapacitated to be executed. So the United States Supreme Court has said in its wisdom that we aren't going to legally allow the execution of people who are incompetent to know that they are being executed and why they're being executed. So we can assert that they're incapacitated to be executed. We transfer them to a mental health facility. Then it's the job of the mental health facility and its mental health professionals to restore their capacity. And when you restore their capacity, then they get transferred back to carry out the sentence, which of course is execution. The American Psychiatric Association has observed that this, of course, it would be it's problematic as far as the Hippocratic Oath is concerned to be treating someone incapacitated to be executed, successfully treat them, and have them where the consequence is going to be that they're executed. There are also some interesting, I guess, philosophical issues, if not clinical issues, of so what's really rational and irrational, what's crazy and not so crazy. Waiting to be executed, is it a normal, rational response to decompensate and become ill? Or if you're incapacitated to be executed, what is the rational, sane, appropriate response from a patient standpoint, let alone a provider or mental health professional standpoint? So we have a series of ways of moving from the criminal justice system to mental health services, and a series of cases that have addressed those transfers. I've also talked about I've talked about both civil commitment authorities, the police power and the parents patriae power, and challenges with those. And given the problems that we have with the criminal justice system and what really is going on with diversion, incompetence to stand trial, not guilty by reason of insanity, incapacitated to be executed, given the problems of both the police power and the parents patriae power regarding accuracy and efficiency and error rates, there are those who suggest that as you understood the criminal justice system, relatively straightforward legally and ethically, and as you understood the healthcare system, relatively straightforward legally and ethically, and what's more challenging and ironic are those aspects of the mental health system with authority to compel people to submit to care. There are those who argue and assert that involuntary civil commitment could be abolished and should be abolished. The arguments, the policy arguments against involuntary civil commitment are generally four. One, mentally disordered persons should not be legally distinguishable from normal persons. If in the healthcare system you can consent to or refuse any and all treatment, even if the consequences are that you die, as a matter of law, if not ethics, why not have that be the case as far as persons with mental illness are concerned? What is different? What is distinguishable? And indeed, there's a phenomenon in the literature called sanism or mentalism that suggests that you can begin to make arguments with respect to people who are mentally ill that we have social and legal phenomenon of mentalism or sanism, discrimination against persons with mental illness on the basis of their mental illness. And that one reason why we have this separate mental health system if not intentionally, at least on a de facto basis, is an outgrowth of this phenomenon of mentalism or saneism, discrimination on the basis of mental health. And that the phenomenon of mentalism, discrimination on the basis of mental illness, is enjoyed in the same social system situations as discrimination on the basis of race, gender, ethnicity, and the like. So we find discrimination against persons with mental illness in employment, in education, in housing, in healthcare itself. And the mental health system, this authority to compel people to submit to care for only persons with mental illness, is really a sanist phenomenon. Indeed, we have, in the last decade or two, had statutory remedies, federal statutory remedies, as well as state statutory remedies for such discrimination, including the Americans with Disabilities Act. We have had a civil rights movement for persons with mental illness, are having a civil rights movement for persons with mental illness, for persons with developmental disabilities. And those legal remedies, those anti-discrimination statutes at both the federal and state level, track the civil rights movement for African Americans, for ethnic minorities, for other racial minorities, gender and the like, in attempting to address discrimination in housing, education, employment, and health care. So, one argument is mentally disordered persons should not be legally distinguishable from normal persons. Why do we treat people who are mentally ill different legally and ethically from the way we treat people with diabetes, with cancer, or with any other chronic, debilitating, or acute situation? Secondly, the involuntary commitment system produces unacceptable numbers of improper commitments, at least from a legal standpoint, if not an ethical standpoint. The number of false positives, the number of false negatives in both the police power commitments and the parents patriae commitments. Third, the states, historically and currently in many states, do not provide adequate care and treatment to involuntarily committed persons. Now, there's another irony here in that you can in some ways you can characterize involuntary civil commitment as a socialized, I'm putting these in quotations and being intentionally annoying, if not aggravating. You can characterize involuntary mental health system, involuntary civil commitment system, as being our socialized mental health system. So while it's involuntary, you nonetheless will get state-subsidized, state-paid service in the state hospital or involuntary outpatient commitment that's paid for by the state. We can get to the point of, in some states historically, since it's paid for by the state, there are some legislators in some states who have come up with the idea of, you know, the people or their family really ought to pay for that care. And so some states have periodically established programs for going after family members to get that care paid for. They've tried that for about a year and realized it costs more to try and get reimbursement from family members and friends than you get to help your budget. I would, as a side note and analogy, I would also point out that some states have also periodically tried to get that for the prison population. Let's make the family members, if not the inmates themselves, pay for their own care. And again, the cost of implementing that program has proved to be more than was recovered from inmates. So the states don't provide adequate care and treatment to involuntarily committed persons. Fourth, hospitalization is not necessary for the efficacious treatment of mostly involuntarily committed patients. As I was talking with Dr. Tasman this morning, Kentucky, like other states, has some diversion programs. Many of the incompetent to stand trial population could not only be assessed on an outpatient basis, they also could be treated on an outpatient basis, but politically and socially we're reluctant to do that because that population is perceived to be dangerous And when we make a mistake in the criminal justice system, the mistakes will get recorded on the front page of the newspaper. We'll hear about them, and we will have the phenomenon of identifiable lives and policy made on the basis of identifiable lives rather than statistical lives. Or in public health terms, instead of using population data, we'll do policy by anecdote or by dog and pony show. Benefits of the abolition of involuntary commitment would include several things. One, the extension of liberty. And here we mean physical liberty. There's a defense of involuntary commitment called the so-called thank you theory, which is we'll treat them involuntarily, we'll compel them to receive treatment, and they'll thank us later. And when they thank us later, that's sufficient justification for the initial commitment. And there's also the phenomenon of being mentally free to be free. So the criticism of the legal system's emphasis on physical liberty and physical freedom being that from a mental health standpoint, physical liberty and physical freedom and the physical liberty and freedom of homelessness and the tragedy and trauma of and quality of life of homelessness is inappropriately valued by the legal system. And that people in that situation aren't truly mentally free to be free if as a result of their mental illness, and there are estimates that roughly a third of the homeless population are mentally ill or were formerly hospitalized or should be hospitalized or should at least receive mental health services, that the extension of liberty asserted by the law and by some ethicists is a false promise, and that if you're not mentally free to be physically free, what difference does the physical freedom make? Responses to that, that gets to be challenging as far as the legal system is concerned. We can pretty readily measure physical freedom and physical liberty. It gets more challenging to define, measure, prove the lack of mental freedom, or to define the lack of mental freedom. Secondly, another benefit to abolition would be benefits to mental health professionals. Mental health professionals, as in my example of incapacitated to be executed, have dual roles when they're facing work in the criminal justice system, the healthcare system, and the involuntary civil commitment system. They're facing roles not just as traditional health providers on an informed consent basis, but they're also facing roles as jailers, as social control agents, where their true client, as Irving Goffman used the term, the true client of the mental health system is not so much the patient as it is victims, providers, society at large, and perceptions regarding public safety. So benefits to mental health professionals of eliminating or minimizing the authority to compel people to submit to care would be enhancing their role as health professionals, where care is received on a voluntary basis. We certainly have some insight that mental health care and treatment works best when somebody seeks care, when they recognize they have a problem and want it addressed, rather than when it's compelled, coerced, or the product of duress. Another would be the enhancement of treatment. This is that treatment is enhanced when there's cooperation and voluntary seeking of treatment, acknowledgement of need for care, and cooperation with the service. And then the cost savings. We have a fairly inefficient, from a cost standpoint, mental health care system. We've got a lot of time, energy, and opportunity costs spent on the legal process to compel people to receive care that arguably could be better spent. So we've got several arguments for and several examples of the kinds of benefits that would result. What I've been interested in as far as the guardianship system is concerned is the extent to which guardianship, and especially a public guardianship system, could facilitate this. So that if we go back to, we really need to have distinct criminal justice and healthcare systems, and the mental health care system as it exists to compel people to submit to care could be divided between criminal justice and health. Part of doing that is the premium that that would place on the incompetency system and the guardianship system, so that what's recommended regarding abolition of the involuntary civil commitment system is really radical, if not naive and unrealistic, especially if there's not a viable guardianship system to address especially the parents patriae population, but also arguably the police power population, where you could say that incapacity is an important, where you could say that legal incapacity is an important part of the police power. Now, this was all with respect to adult mental health. I want to pause for a moment and give you the 5 or 10 minute version of children's health law, if not children's mental health law. So what I've talked about so far has been the adult criminal justice system, the adult mental health system, and the adult health care system. And I guess it's Justice Cardozo's famous quote in the Schlorndorf case that adults of sound minds have a right to control what gets done with their bodies. He actually didn't say adult, he said males. It was early 20th century. And he emphasized adults. He didn't talk about children. Children legally, and I'm first going to talk about children in the healthcare system, children legally, unlike being presumed to be legally competent, are, as a matter of law, presumed to be incompetent by reason of age. And the law, in its infinite wisdom, makes that a very bright line. So at 17 years, 11 months, and 28 days, you're incompetent by reason of age. In 2 or 3 days, on your 18th birthday, you're now competent. So we have a very bright line with very bright legal consequences to that. There are all sorts of discussions we can have regarding that bright line, but let me quickly describe the legal framework then for children. So if you've got a presumption of incompetence for children, that means they're presumed to be incompetent as a matter of law, and their parents are presumed to be their natural guardians, and their parents are presumed to have the authority to consent to or refuse any and all treatment, even if the consequences are that the child dies. That's the starting point analytically. Then what the law does is start carving out a lot of exceptions as far as children's health law is concerned. The exceptions include some of the following. First of all, we have abortion. And putting aside the very serious religious, moral, ethical debates that I acknowledge, and when I cover the law of abortion with my students, I try to emphasize that a substantial number of women have had abortions in the class, a substantial number of males in the class have had some responsibility for that, some involvement in that. This is a very personal, moral, religious issue about which people have strong feelings on both sides, and I'm going to describe the law as it is. I'm going to minimize the extent to which we talk about ought. But one exception then starts with abortion. So we have said descriptively that females under the age of 18 can't be prescribed yet the right to have an abortion. We save constitutionally most of the abortion statutes by requiring that there be a so-called judicial bypass. So one of the exceptions to legal incapacity of women under 18 to have an abortion, one of the legal exceptions to the presumption of incapacity is the ability to have an abortion. So females under age 18 can consent to an abortion. They ultimately can get an abortion through a judicial bypass procedure. That's one exception. Another exception are so far. I'm going to keep emphasizing so far. The makeup of the Supreme Court is changing, of course. We're having an election, and we've been systematically changing the votes on abortion and limiting the right to abortion in the last decade or two. Second exception as far as children are concerned is contraceptive services, males and females. Public health issues like treatment, voluntary treatment for minors of venereal disease. Then we have certainly the ability of persons under age 18 to get, curiously, mental health, drug abuse, alcohol services on a voluntary basis, even though they're under age 18. These are also exceptions in many states. And then we cover everything else, and everything else gets difficult legally. There's some good social science research, behavioral science research that looks at the ability of persons under age 18 to consent to and refuse treatment. And what that research has found, and I've done some of it regarding children's mental health and substance abuse services myself, what that research generally shows when they look at the ability of persons under age 18 to consent to or refuse services compared to people over age 18 is that people from age about 18 to age 15 can consent to or refuse treatment both as good and as well and as poorly as 18-year-olds, 22-year-olds, and 26-year-olds as an empirical matter. So they're both as good at doing it and as bad at doing it. The bright line that the law has from a behavioral standpoint doesn't make much sense. From about age, and I'm emphasizing about, from about age 15 to about age 9, children are, while having some ability to consent to or refuse treatment, both healthcare treatment services, cancer treatments, heart treatments, for example, diabetes treatments, as well as mental health, drug abuse, and alcohol services, while 9 to 15 have some ability to do it, they aren't as good at it as 15 to 18-year-olds. And again, please understand I'm generalizing for policy purposes, population health purposes. And so the law, there are recommendations, there are policy recommendations that the population age 9 to 15 should, if not have the ability to consent to or refuse treatment, they should be able to assent to treatment. Assent being operationalized as, well, they should be involved in the informed consent process. They shouldn't have the ability to veto, but they should definitely be involved. I would add some other exceptions as far as children's health care is concerned, include religious issues. So parents may generally not impose their health decisions made for religious reasons on their children. Their children have some religion rights, but parents may not impose their religious preferences and healthcare decisions on their children. Now, ages 9 and below, as a matter of social science, generally have very limited, if any, ability to consent to or refuse treatment. So as a result of that research, what some have recommended is the law ought to, or the law policy ought to increase the ability of 15 to 18-year-olds to consent to or refuse treatment authoritatively. And frankly, we're probably getting there with the so many exceptions that swallow the rule. And we ought to be more attentive and aggressive about involving ages 9 to 15-year-olds in assent as far as their treatment is concerned. So children's health law and the children's health care system and its subset, the mental health law and the mental health care system, has its own set of presumptions, which I guess conceptually are essentially the reverse. So you start with presumption of incompetence and carve out a lot of exceptions as far as children are concerned. And with adults, you start with a presumption of competence and continue from there. Let's see. I guess what I'll conclude with is what I'm currently doing as a continuation of my own health and mental health law and policy research agenda and interests. We are still in the process of writing up a replication of my 1978 study that was recently concluded, and we've already published an article in the Stetson Law Review that just came out, even though it's dated 2007. I have a book chapter coming out on a mental health theory approach to law and aging in a Theories of Law and Aging, Jurisprudence of Elder Law book that's in press. I'm also working on a book chapter on the legal and financial environment for human resources management and healthcare organizations. I'm going to be talking about coordinated quality improvement programs at the Washington Ambulatory Surgery Center Association meeting. We've got some more public guardianship practice presentations, including at the National Guardianship Association annual conference. I'd like to continue an article, do another article on per capita guardian certification sanctions in the state of Washington and the relationship between certification experience requirements and guardian sanction. An article on whether guardians should be licensed and regulated under the executive branch rather than under the courts. Doing a third book, updating my first book on public guardianship after 25 years. And I've been asked to do a book on stopping abuse and crimes against the elderly. So at this point, regarding this introduction to mental health law and policy, I will conclude, and I think there's time for questions. I'd be happy to answer any questions and make this much more of a seminar.
We have time for questions, so if anyone has a question.
What are the rights of children under age 9? Specify age 9.
Mm-hmm. Generally, they're...
Repeat the question, please.
Yes, I'm sorry. Yeah, I'm sorry. Thank you. The question is, what are the rights, what are the legal rights of children under age 9? As a matter of law, just as there's a presumption of incapacity under 18, and there are no rights, but you carve out a lot of exceptions, under age 9, the presumption of incompetence, incapacity is even stronger, and they have very few rights, except for, I think I would judge the religion rights to be probably the strongest for persons under age 9. But people could disagree, and I may be missing one. Do you have anything particular in mind as far as persons under age 9 are concerned?
Well, in my work, I work with children.
Mm-hmm.
I have a child who is 15,
Mm-hmm.
who has a child who is 1.
Mm-hmm.
And we...
Children having children.
Yes.
Mm-hmm.
We're struggling with looking at the rights of the infant and the rights of the mother,
Mm-hmm.
and kind of trying to beat out what's what.
Mm-hmm.
As far as continued care, whether or not the child should be in the mother's home,
Mm-hmm.
and all of that, everything that goes with that. And that's
Mm-hmm.
one thing in particular that I'm interested in.
Mm-hmm. Okay, so to repeat it for everyone, if you didn't hear, the continuation of the question or the follow-up was, for example, we have a situation of care for a child having a child. In the textbooks and in the courses, the children having children is the way it's characterized. The legal analysis starts with the presumption of legal incapacity for both. And then you proceed. So you first, from a legal analysis standpoint, and I personally would say from an ethical analysis standpoint, although that's certainly more debatable, you start with the incapacity of the older child and you determine who the substitute decision maker is. Hopefully you have hopefully you have the natural guardian. You first start with the natural guardian, the parent of that 15-year-old. To make it really hard, you'll say there isn't any. And to make it also realistic and more challenging, there isn't any. So, and this, with respect to my guardianship research, this is the phenomenon of no willing and responsible family members or friends to serve as guardians. So no natural guardian. So you next look for a guardian. You'll also say, I will say the next step is, well, are there resources to hire a professional guardian? You will probably say, no, there aren't any resources to hire a professional guardian, to make it harder and to continue our dialogue. And to keep making the question harder so I'm not able to get out of it. So you have no willing and responsible family members or friends to serve as guardian. You have no resources to hire someone to serve as guardian. You now have the problem of public guardianship. So I say you now hopefully have a public guardianship program. You go to the public guardianship, you petition the court for appointment of the public guardian as guardian for that child. And then the guardian starts with all the rights of that individual as if they were competent, including starting with the 15-year-old as the natural guardian, conceptually as the natural guardian of the 1-year-old, and the public guardian would see what can be done under those circumstances. Okay? Now, to make it really difficult, you will say, or you can say, but that's fine, but we're really concerned about this 1-year-old, and it may not be that the natural guardianship is easy or viable, or you don't have a public guardianship program, or the public guardianship program is understaffed and underfunded. Okay, now what do you do? We have other exceptions like emergency, so you've got the authority to treat on an emergency basis. We've got the ability to do single court transaction ratifications of desired treatment, so one can and arguably should, in the absence of any of these other solutions, go to court and say, we want XYZ treatment, court-ordered, either physical or mental health services for both children, one or the other or both as a unit, whatever may be the case. I think the important thing is to start with the presumption of incompetence and getting a substitute decision maker or substitute decision. I think we start getting into lots of trouble when we start jury rigging a variety of alternatives that have not so clear legal authority, let alone ethical authority. Now, I also readily recognize and acknowledge that all that's a lot easier to say than do. It also highlights some policy challenges, including putting a premium on, if this is my response, and if this is, I think, the correct response as far as the legal system is concerned, that puts a premium on the need for public guardianship and a viable public guardianship system. Not only from the standpoint of those individuals and the situations and conditions and public health circumstances that they represent, but also from the standpoint of the community generally, cost efficiency, correct roles as far as the various providers are concerned, facilitating funding, the whole panoply of consequences intended and unintended. Is that responsive for now? I'd be happy to continue the discussion.
In the homeless service system,
I'm sorry, in the what system?
The homeless services system.
Yes.
The homeless clients that are seriously mentally ill or have a dual diagnosis Some have been found to be treated better in the community with good community-based services, particularly the assertive community team approach. And this has led to reduction in large institutional cost for them. However, some of the clients in the system are kind of resistant to this because there's the requirement in some of the ways that these are set up that if you have a substance abuse problem, you're sober. Or if you're taking drugs, you're no longer taking drugs as a condition for getting into the treatment. Some of the client advocacy groups have been arguing for less preconditions like that. And they've been pushing the housing first concept so that people get in even though they may have the condition. How are the courts likely to be looking at this from a judicial question in terms of this public policy that seems to be promoting the housing first approach rather than the more controlled assertive community team approach?
And the question, to repeat it for everyone, as I'm understanding, please correct me if I've misstated, the issue of the homeless population, requirements of some programs to have eligibility criterion that if you conceptualize the homeless problem as, first of all, a lack of homes and try to find housing as a first priority, some programs have the approach that you're only eligible and can only get housing under the program if you don't also have the problem of alcohol and drugs, and you've got to be wholly drug or alcohol free in order to qualify, is generally the problem as I understand it. Realistically, well, let's see. Let's do the ought first. So in the legal system, the way I think it ought to work and the way I think probably some legal advocates and attorneys for client advocates would, I think what they would say under those circumstances, the legal argument would say, I mean, most easily, that frankly it's discriminatory under the ADA or some other remedy, statutory or case law. It's discriminatory to prevent somebody who's otherwise eligible for housing from receiving that housing benefit when you condition it on a criteria that is arguably discriminatory. That is, they're choosing, not to be free of drugs or alcohol. That would be the legal argument, also the ethical argument, also a policy argument. On the other hand, and making the question harder, that's fine, that's the technical, academic, legal response. The reality is, am I going to be able to easily find a judge who's sympathetic to that, either state or federal? Not necessarily. It puts a premium on the hard work and the good work of effective legal advocacy as well as policy advocacy. So I can give you the theoretical response, which I think is essentially correct, but taking the question to be the harder one of how likely are courts to be sympathetic to that, frankly, in my opinion and others, the judicial environment of the United States Supreme Court, as well as many state courts, is not as friendly as it has been and maybe will be. Among other things, on the ADA, the United States Supreme Court keeps limiting the ADA, and Congress keeps turning around and saying, no, we really meant that. It was too broad for you, but fine, we'll make it more specific, and they put it back in. So there's this back and forth between the court between the Congress and the federal court system. Again, all of that is very much overstating things and ends up being on a case-by-case basis. Is that responsive? Mm-hmm. Yes?
Sometimes in the case of really heinous crimes like murder or torture, little children it's announced that they're going to be tried as adults. And it's almost like the prosecuting attorney says, well, you were so mean, you were really like an adult. Mm-hmm. So it seems to me that this happens very easily, I mean, as a layperson.
Yes.
So can you address that? Like, why should a 13-year-old who butchers a 12-year-old, why should they be tried as an adult? I just don't see it myself.
Yes. And to repeat the question for everyone as I'm understanding it, please correct me if I don't state it accurately. So you're talking about, in the criminal justice system, children being tried as adults in situations where the crime is so heinous or the prosecutor's political inclination is this is one where they've perpetrated an adult crime, therefore they should be treated like an adult. So the public political response frequently is, as I've described, we're not, and let me go back to what I've tried to outline here as the legal framework. I talked about children's health law and children's mental health law. I didn't talk about the juvenile justice system. Historically, the juvenile justice system has been similarly bifurcated, so that the juvenile justice system was initially designed to relieve juveniles under age 18 of adult responsibilities because they were below 18. And a premium was placed early on in the juvenile justice system that instead of punishing, what we needed to do with respect to persons under age 18 was to treat or rehabilitate. And so the juvenile justice system was designed initially to take a treatment or rehabilitation approach, and we designed all kinds of things to be associated with that concept. Treatment, that system historically, arguably, has either not worked, so the argument goes, or not been sufficiently funded, so the argument goes. And we have started to carve out policy exceptions to that general framework and say one of the exceptions is, for example, if you perpetrate XYZ crime, we're going to allow prosecutors we're going to allow the system to take the juveniles out of the juvenile justice system and put them into the criminal justice system. So the why is political. To be consistent with the conceptual framework that I've laid out here, you can argue, I think it's legitimate and appropriate to argue based on this framework and conceptualization and based on that idea of having a separate juvenile justice system was a good one. Based on that, you can say, you could say that that you shouldn't allow such individuals to be tried as adults for a variety, and the best arguments are going to be public health arguments, are going to be population health arguments regarding outcomes of, so what happens when you do that, when you treat children like adults in a criminal justice system? You get lots of bad results. So I think the responses are population health in nature. Are they necessarily viable or successful politically or as a matter of public policy, or would I be particularly optimistic that that trend will change? No.